Good morning and welcome to PV Legal's daily newsletter. Today's story is not a tragedy. It is not even a legal thriller. It is, frankly, a comedy featuring a GST officer, a 23 crore refund, and a very creative interpretation of the word 15. Meet Golden Cryo Private Limited, an exporter, a law-abiding taxpayer, someone who filed a perfectly legitimate refund claim of rupees 23 crore 67 lakh accumulated input tax credit on exports in October 2025. The application was acknowledged. The clock was ticking. All seemed well. Then came December, and with it, our protagonist, the Assistant Commissioner, CGST, Nashik Division. On the 12th of December, the officer issued a show cause notice to Golden Cryo, alleging that their suppliers were dealing in fake invoices. Fair enough, that's a serious allegation, but here's where it gets interesting. Rule 92.3 of the CGST rules says, give the taxpayer 15 days to reply. Our officer, apparently working from his own edition of the rulebook, gave them 7 days, not 15, because why follow the law when you can have it? Golden Cryo, undeterred, filed their preliminary reply by email on the 19th of December. They asked for a personal hearing. They specifically cited Rule 92.3. They did everything right. And on the 20th of December, the very next morning, the officer rejected their entire 23 crore refund claim. He had not read the reply. He had not given a hearing. He had not issued the mandatory RFD-09 notice. He simply moved on. His defense before the Bombay High Court? The reply was filed by email, not on the portal. Therefore, in his view, no reply existed. Therefore, no hearing was needed. Natural justice, quote, wholly misconceived, unfounded, and devoid of any legal merit. The Bombay High Court, Justices Kulkarni and Sathe, responded with the judicial equivalent of a raised eyebrow. They found the officer's approach totally flawed. They noted the notice itself was illegal, the rejection was arbitrary, and the haste, and I quote, was completely opposed to the rule of law. They quashed the order, they directed fresh proceedings, and they told the higher official and CBIC board, find out why your officers keep doing this. The lesson from Golden Cryo is simple. Rule 92.3 is not a suggestion. 15 days means 15 days. And passing a 23 crore rejection order the morning after receiving a reply is not efficiency. It is litigation manufacturing. This has been your host for PV Legal's daily newsletter. Stay informed, stay protected. Good day with PV Legal. Stay shining, stay informed.